Leave of absence under Law Number 104/1992, the ambiguous position of case law on employee abuse. Law Number 104 of February 5th, 1992 recognises the possibility for the employed worker to take special leave to care for disabled relatives. In the face of the right recognised, one would expect ethically unimpeachable behaviour from the employee, first and foremost toward that employer which suffers organisational dysfunction as a result of the leave taken. Increasingly, however, there are cases of abuse on the part of employees who take advantage of the permits in question, not to assist their disabled relative, but for personal or recreational purposes, sometimes even to carry out other work activities, to the detriment of the employer and of IMPS, the body providing the economic benefit. When discovered by the employer, such illegitimate conduct results almost always in the dismissal of the employee, and in many cases, in the jurisprudence judging the legitimacy of the dismissal itself. In its recent order number 16973 of May the 25th, 2022, for example, the Supreme Court confirmed the seriousness of such conduct, ruling that it was legitimate to dismiss an employee who had used leave under Law Number 10492 for private and non-welfare purposes, even if only for 4.5 hours out of the total 32 hours taken. The court thus found that by such conduct, the worker had demonstrated a substantial disregard for the company's needs, violating the principle of good faith and fairness in the execution of the employment contract, such as to result in the employer's loss of confidence in subsequent performance and capable of justifying termination for just cause. In the face of such pronouncements, there is no shortage, however, of cases in which jurisprudence has found the abuse of the permits in question to be a fact not sufficiently serious to legitimise the expulsion sanction. Moreover, to consider that the same cassation referred to above, 16973-2022, overturned the judgment on the merits in which the Court of Appeal of Perugia, judging the same case in the opposite way, held that the conduct, although disciplinary relevant, did not have connotations of gravity, such as to consider the fiduciary relationship between employer and employee irreparably damaged. In conclusion, the jurisprudence fails to find a synthesis and take a clear and consistent position on an issue as relevant to the lives of workers and companies as the leave of absence under consideration. In the overall assessment of the facts, however, one cannot disregard as a starting point the fact that the illegitimate use of a leave under Law Number 10492 represents first and foremost the abuse of a right, the failure of the worker to the principles of fairness and good faith that should underlie the employment relationship, as well as organisational and economic damage caused to the employer and the company that bears the cost of that misused leave. Filippo Salvo, lawyer.